In this video, I'll review the foundational United States federal legislation after 1990. These 6 acts shown in the boxes are listed from earliest to most recent. They'll be covered in summary format, indicating who they apply to, the provisions and compliance requirements. The website where the full act can be found is provided. The Americans with Disabilities Act, ADA, of 1990 was first proposed in 1988, and it was backed by thousands of individuals around the country who'd been fighting for rights for their family members, friends, and co-workers to have equal access to community services, jobs, trainings, and promotions. The act was finally signed into law by President George H.W. Bush on July 26, 1990, and became fully effective for all employers with 15 or more workers on July 26, 1992. Prior to this legislation, the only employees who were protected against disability employment discrimination were the ones working for the federal, state, or local government and federal government contractors who were captured by the Rehabilitation Act. This act covers employers with 15 or more workers on the payroll and may not discriminate against a physically or mentally disabled individual in the recruitment, hiring, promotions, training, pay, social activities, or other privileges of employment. Qualified individuals with a disability are to be treated as any other job applicant or employee. If a job accommodation is required for a qualified individual to perform the assigned or essential job functions, the employer is required to provide that accommodation or recommend an alternative that would be equally effective. The interactive process between the employer and the employee should result in an accommodation or an explanation as to why making the accommodation would provide an undue hardship on the employer. Enforced by the Equal Employment Opportunity Commission, it provides guidelines to encourage employers and individuals to work together to determine what are the appropriate and reasonable accommodations rather than the employer alone making that judgment. Job accommodations are situationally dependent adjustments to a job or work environment that makes it possible for an individual with a disability to perform their job duties. The table displayed identifies the key considerations. Disability. Employers are required to consider as disabled anyone with a condition that substantially limits but does not significantly restrict a major life activity, even though the limitation might be reduced or eliminated with medication or other alleviations. The treatment may not be considered when determining the limitations. This qualifies employees who use shoe inserts to correct back problems or who take prescription sleeping pills, or those who are allergic to peanuts or bee stings may now be classified as disabled. However, there may be no request for a job accommodation. Essential functions. An essential function is defined as a portion of a job assignment that cannot be removed from the job without significantly changing the nature of that job. In the job analysis, these are the duties listed first, and when possible, given the percentage of time performed, as it indicates the special qualifications, skills, or abilities to perform that function. Accommodation requests. There must be a request for accommodation from the employee to provide that accommodation before any action is required by the employer. It's perfectly acceptable for an employer to request support and documentation from medical experts to identify the disability. There might even be recommendations for specific accommodations, including those requested by the employee. Reasonable accommodation. The ADA requires covered entities to make reasonable accommodation to develop employment opportunities for qualified persons with disabilities in 2 areas. Facilities should be accessible to persons with disabilities, and the position requirements may be adjusted to accommodate qualified persons with a disability. The Act identifies the factors to be considered in determining whether an accommodation is an undue hardship by looking at the costs, financial resources of the organization, the size of the organization, and other similar factors. To curtail the impacts of the 1980s staff reduction programs imposed primarily by large employers, Congress took action to prevent such treatment based on age when it passed the law of the Older Workers Benefit Protection Act of 1990. The act prohibits an employer from using an employee's age as a basis for discrimination in benefits, targeting older workers during staff reductions or downsizing, and requiring older workers to waive their rights without the opportunity for review with a legal advisor. The Act has a mandate for employers to use specific words and safeguards intended to protect older workers to make sure that they are not convinced to sign a waiver without fully understanding it. The employee has 21 days to consider that agreement and consult an attorney. If it's a group termination, 45 days is allowed. Once a waiver is signed, an employee has legally agreed to give up their right to serve a lawsuit on the employer based on age discrimination or any perceived wrongdoing. Employees will have 7 days to revoke this agreement after it's signed. In exchange for signing this waiver, an employer will often provide some sort of benefit to the employee that isn't usually offered, like increased severance pay. The Civil Rights Act of 1991 was passed into law by Congress on November 21, 1991, and was the most complete civil rights legislation since the Civil Rights Act of 1964. It ensued 2 years of debate to prohibit discrimination for job applicants and workers based on race, gender, religion, color, or ethnic characteristics. However, the Act did not apply its rules to businesses with less than 15 employees, nor did it address employment discrimination based on sexual orientation. Following the 1989 Supreme Court ruling that diminished workers' ability to sue employers for discriminatory reasons, the 1991 Act strengthened the 1964 law, particularly in the terms of liability of employers and the burden of proof, and added new legislation. It modified some basic procedural and substantive rights under federal laws in the area of employment discrimination. It offered a trial by jury option in discrimination cases. It also presented the first opportunity to collect emotional distress damages and limited how much juries could pay out. The Civil Rights Act of 1991 was enacted to provide suitable solutions for purposeful discrimination and illegal employment harassment. It categorized the terms job-related and business necessity, which was articulated in the Supreme Court in Griggs v. Duke Power of 1971, a landmark case, and in the decisions before Ward's Cove Packing Company v. Antonio in 1989. These amendments affected Title VII, the Age Discrimination in Employment Act, and the Americans with Disabilities Act. The Civil Rights Act of 1991 placed a limitation on the punitive damage awards by using a sliding scale dependent on the size of the employer organization using payroll headcount. As shown on the table, for employers with more than 500 employees, damages are capped at $500,000. For employers with 201 to 500 employees, damages are capped at $200,000. For employers with 100 to 200 employees, damages are capped at $100,000. For employers with 15 to 100 employees, damages are capped at $50,000. When the EEOC pursues a multi-person claim, the damage caps are applied to each person in the claim. President Bill Clinton signed the Family and Medical Leave Act, FMLA, of 1993, which was created to assist employees in balancing their needs of families with the demands of their jobs. In addition to protecting employees from adverse employment actions and retaliation when they request leave under FMLA, the Act provides 3 benefits for eligible employees covered in organizations: 12 weeks of unpaid leave within a 12-month period, 26 months for military caregiver leave, continuation of health benefits, and reinstatement to the same position or equivalent position at the end of the leave. The Act applies to all public agencies and schools regardless of their size, and private employers with 50 or more employees working within a 75-mile radius. Both employer and employees have eligibility requirements. Employees or the Secretary of Labor can bring enforcement action. This act is very involved with very specific requirements, so well worth reading more details on how it applies. On September the 25th, 2008, President George W. Bush signed the Americans with Disabilities Act Amendment Act of 2008, which took effect on January the 1st, 2009. According to the language in the amendment, Congress took the action to clarify the intention of the original legislation, which was to make the definition of disability consistent with the way the courts had defined the term under the Rehabilitation Act of 1973. The Act emphasized that the definition of disability should be construed in favor of a broad coverage of individuals to the maximum extent permitted by the terms of the American with Disabilities Act, ADA, and generally should not require extensive analysis. The Act makes important changes to the definitions of the term disability by rejecting the holding in the several Supreme Court decisions and portions of the EEOC's ADA regulations. The effect of these changes is to make it easier for an individual seeking protection under ADA to establish that he or she has a disability within the meaning of the ADA context. The court interpretations under the ADA had narrowed the broad scope of protection originally intended, and the amendment more clearly describes the intent of Congress and its rules of construction. This table shows a summary of the 9 rules into 6 categories. Substantially limits. This rule underscores the Amendments Act expansion of the definition of disability and expansion of persons now covered under the ADA due to the elimination of extensive mitigating measures court case history. Expanded impairments covered. An impairment does not prevent or severely or significantly restrict performance of major life activity to be considered substantially limited. Not every impairment will be a disability, but the list is broader and emphasizes the change that impairments have to permeate work and life activities. Disability determination. Primary focus should be on a person's qualifications for a job needed for reasonable accommodation or whether the discrimination occurred. Extensive analysis should not be required. Individualized assessments. This is still a requirement, but substantially limits is a lower standard than pre-Amendment Act. It is important for employers to realize that although on a case-by-case inquiry an analysis is relaxed, it has not been eliminated, and it is still a mandatory phase of the disability determination and reasonable accommodation analysis. Mitigating measures. Congress directs that except for ordinary glasses or contact lenses, mitigating measures such as medication, prosthetics, hearing aids, mobile devices, and others may not be used to define disability. This clearly underscores that the entire 19-year history of court cases establishing mitigating measures was overturned by the Amendment Act. Episodic remissions and impairments. Many conditions were controlled under the application of mitigating measures. Now, such conditions can be considered as evidence of the presence of a disability. The Lilly Ledbetter Fair Pay Act of 2009 was the first piece of legislation signed by President Barack Obama after he was inaugurated as the 44th President of the United States. It was passed in reaction to the U.S. Supreme Court's decision in the Ledbetter versus Goodyear Tire and Rubber Company in 2007. The law amends the Civil Rights Act of 1964 and states that the clock will reset each time an illegal act of discrimination is experienced by an employee. In Lilly Ledbetter's situation, her pay was less than that of men doing the same job. The old law didn't permit her to succeed her complaint of discrimination because she failed to file 20 years earlier on the first occasion of receiving a check for less than her male counterparts. Under the new law, the 180-day statute of limitations for filing the equal pay lawsuit regarding pay discrimination resets each new paycheck affected by that discriminatory action. It would be wise for employers to be proactive and identify and correct any potential discriminatory pay practices.